I'm Rafa Sonnenfeld. I'm a lead with Cruz YIMBY, and we have a special presentation tonight. For those of you who don't know, in my day job, I am the director of legal advocacy at YIMBY Law. My job is basically to help enforce state housing law throughout California. We sue cities when they break laws, and today we're joined by some of my colleagues who work for, we have Ryan Patterson and Emily Brow. I hope I'm pronouncing that right. And I work with them basically every day. They are outside counsel to YIMBY Law. And yeah, Ryan, take it away.
All right, thanks a lot, Rafa. Great to meet you all. I'm Ryan Patterson. Not my first or Emily's first Santa Cruz YIMBY meeting, so it's nice to see some of you again. So as Rafa said, I'm Ryan Patterson. I'm a partner with Zacks, Freedman Patterson, and we have offices in SoCal, in San Francisco, in Oakland, and we represent YIMBY Law. We also represent developers, real estate developers, housing advocates, a pretty wide variety of clients. And nearest and dearest to my heart is trying to get more housing projects approved. And so as we work in this day in, day out, we've developed some, I would like to think, some amount of expertise in how to cut through the red tape and how to use state law to get around some of the local regulations that cities impose to try to prevent housing from being approved. So that's what we're talking about today. We're going to go through a few of those laws and how they can be used as a sword to cut through red tape. And happy to take questions, and we'll do some, I guess, minimal Q&A as we go along, and then take more questions at the end as well.
Yeah, I just also wanted to invite folks to pop questions into the chat, but we're anticipating maybe about half an hour worth of slides and commentary and questions at the end, but we can take a little time to answer pertinent questions sort of as we flow through.
Great. And I should give a standard admonition that in these types of discussions and presentations, while we're talking about the law, you should not take it as legal advice. If you are a developer or a potential litigant, if you want to sue your city, you should talk to an attorney, consult with an attorney, and get legal advice for your situation. So with that said, Emily, would you like to start the slides? And we'll jump right into it. All right. Great, thank you. So the first topic that we'll be discussing is the Housing Accountability Act, Government Code 65589.5. It's a wonderful piece of legislation dating back to 1982. And originally in 1982, the idea was California is in this unprecedented housing crisis, and we need to take drastic action to solve that. And the drastic action that they looked at was for affordable rental housing only. So it was pretty limited, but over the last 4 decades, it's been expanded to cover not only affordable rental housing, but also market rate rental and sale, residential units only, as well as mixed use projects. And there's lots of nuance to all of these things, but those are the broad strokes. So the basic tenet of the Housing Accountability Act is if you propose a housing development project that meets the applicable objective code standards, including design review standards, then a city or a county is prohibited from denying that project application or approving it on condition that you reduce the density of the project. So if you meet, the height requirements, you meet the setbacks, you meet all of those objective standards, then it needs to be approved. The one exception being if there's a significant quantifiable, pre-codified health and safety standard there's going to be a serious health and safety problem caused by the project, then the city can use that as a basis not to approve the project. But that's a pretty rare thing. We've done a lot of litigation in this area with YIMBY, a lot of successful litigation. And we've gotten to a point of, I think, in large part, changing the way that cities do business to where they no longer feel like they have godlike powers over projects and they can just deny things willy-nilly because they don't like the look of it, or NIMBYs come out and say they don't want, they don't want more neighbors. So Housing Accountability Act is a powerful tool, but it's a game of cat and mouse. And the cities are trying to find ways to get around their state law obligations as well. And one of those big obstacles that we're seeing is the use of CEQA, the environmental law, to try to trump the Housing Accountability Act. Discretionary standards being imposed through conditional use permits, planned unit development requirements, those types of things, which we can go into more discussion, more depth about how to get around those things. The Housing Accountability Act also sets out timelines that have to be met, which is a powerful tool for any developer. It references another body of law called the Permit Streamlining Act. And if you don't comply with the timelines in the Permit Streamlining Act, then the Housing Accountability Act says you've effectively denied the project. So if it takes you too long to approve the housing, you've denied it. There's also a requirement in the HAA, Housing Accountability Act, for a determination of whether your project application is consistent with the applicable objective standards. And for smaller projects, that's 30 days. For larger projects, 60 days. And it's a short window for the city to give you a written determination back saying, this meets standards and we're going to review it on that basis, or you don't meet the standards. And here in writing in black and white are the standards that you don't meet. And then you can challenge that. If the city fails to comply with those timeframes, the 30 or 60 days, then your project is deemed consistent, which is an extremely powerful tool. Because remember, if your project is consistent and compliant with the applicable standards, then the Housing Accountability requires approval. Housing Accountability Act requires approval. So if the city misses its deadlines, then you take a big step forward in the process.
So Ryan, what you're saying is the law deems that the application is complete, not the city.
Complete and consistent with the code requirements, right? Just as a matter of law. If they don't tell you otherwise, the law says, yes, you are consistent. Your project meets the requirements. So what happens if the city does the wrong thing and they violate the law? Who can sue? First off, the developer who proposes the project can sue. Also, housing advocacy organizations that meet certain requirements, like YIMBY Law, have standing to sue. And individuals. And the language of the HAA is a little bit funny in this respect. It says any person who is eligible to apply for residency in the proposed project can sue. That's a relic of the past from the 80s, back before this was expanded to cover market rate for sale housing. So you might ask, well, who is eligible to apply for residency in a house being built that you're going to buy? But I think the takeaway here is it's very broad. Probably most anyone is eligible to file suit challenging the denial of a project under the HAA. Importantly, there is a one-sided attorney's fees provision. So if you sue a city saying that the city wrongfully violated the HAA, denied housing, and you win, the city has to pay your attorney's fees, potentially even with a multiplier. If the city wins, you do not have to pay the city for the city's attorney's fees. There could be some costs that are shifted. That's probably a pretty small amount of money. So that's a powerful incentive for cities not to get into these types of arguments and lose and have to spend a bunch of taxpayer money on someone else's attorneys. As I mentioned, there are gray areas that the cities are trying to exploit. arguably discretionary requirements under conditional use authorization, planned unit developments, the question of whether the environmental law trumps the housing law, and also questions about definitions within the HAA. We're currently in the Court of Appeal asking the question of whether the HAA applies to a single family home that's been proposed. There's a project up in Marin that was originally proposed as a single family home plus an accessory dwelling unit. The city told the applicant, if you remove the ADU, we'll approve it. And if you don't remove the ADU, we're going to deny your project. So as developers often do, and this was just a homeowner or a hopeful homeowner, they took out the ADU, tried to make peace with the city. City turned around and said, well, now that it's only one unit, you don't get protections under the Housing Accountability Act, and we're denying your project. So that's in the Court of Appeal, and we just got our hearing notice coming up in June. I'll pause at this point before I move on to the next topic and ask if, Rafa, if you have anything else you'd like to add or any questions.
I love talking about the Housing Accountability Act. I don't even know where to start in terms of what's interesting about it. I really like talking about like the some of the ways that cities try to claim that projects aren't eligible for the Housing Accountability Act. Like if there is some sort of discretionary review involved, basically, like in San Francisco, they have a what's it called, a conditional use authorization, and the city is alleging that because of they have that those projects aren't eligible for the protections of the Housing Accountability Act. So it's sort of, it shouldn't be the Wild West, but it sort of feels that way. Like everywhere you look, a different city is coming up with some way to get around their requirements to approve housing.
Definitely. Very much cat and mouse. And that plays out both in the courts and in the legislature. So there's constant activity to try to open loopholes and close loopholes. There's a question, to sue, do you have to already live in the city that you're suing? The answer is no. And if that were the case, cities would be even better able to keep people out. You know, people are fluid within the state and between states. People want to move to where their families are, where their jobs are, where they want to retire. And I think the legislature recognizes that if we don't have homes built, then we don't have homes to live in. And so you have to sometimes sue a city to ensure that that home is built. Okay, and there's another question about SB 9. I think we should tackle that one later because we have another section in this presentation about that.
That is a really specific question too, but I would say, you know, there are all sorts of shenanigans that cities could play. Like if the SB 9 project is just a single unit, they may say that it doesn't qualify.
Right, right. And that's one technique for developers to consider. If you're proposing a project, a city may truly believe that the HAA only applies to multi-unit projects. And while they may be wrong, it might be worthwhile to add a second unit to the project just to avoid that debate. And that could be an accessory dwelling unit, as we're going to talk about. So let me move on to SB 330, the Housing Crisis Act of 2019. This is a Skinner bill. Big picture, one of the major things it accomplishes is preventing the reduction of the intensity of residential land use. And that's different from saying a reduction of density. There's a difference between the number of units allowed on a lot versus the amount of residential square footage allowed on a lot, or the number of kitchens, or other elements like that. We're just finishing up victoriously a lawsuit against Culver City, which tried to pull some shenanigans and restrict the intensity of use there. Very significant restriction, really. So SB 330 does that. That's a big thing, but it also had a grab bag of other more fine-tuning changes to the way land use entitlements work that can be really useful if you're trying to get housing improved. And I would add, these things are not just useful for developers proposing a project, it's also useful for advocates. Because if anyone is going to sue, and if a city is going to be afraid of the threat of a lawsuit, then these arguments have to be raised at the administrative level, during appeals, during planning commission hearings, city council hearings. If no one says the words, then it's almost like the law doesn't exist in some ways, or at least it makes it much harder to enforce. And there are plenty of instances, and Rafa does this constantly, where YIMBY and other advocates will put cities on notice that they're about to violate a law. And the cities, I would say most of the time, take note and fix it. Sometimes they don't do the bad thing that they're about to do. So, this is not just a technique for developers. SB 330 limited the number of hearings that a project could be subjected to, so it can get off this hamster wheel of hearing after hearing after hearing. There's now a 5 hearing limit, and that includes continuances, which is great. They could theoretically spread the hearings far out, but at least it's a cap on how many times you can come back. SB 330 also creates a process for what's called a preliminary project application. And it includes a list of items of information about the project that need to be disclosed to the city. And if a developer comes and says, okay, I'm proposing a project with 5 units, it's going to be this tall, here's where it is, here's historic information, et cetera, then that locks in the requirements that that project can be subjected to going forward, even though they haven't even filed an actual application yet. That's a powerful tool. That means that the cities can't go and change the rules just to try to squash a project before it gets to the application stage. Now, the city does not actually have to give a response to that preliminary project application. Just filing it is enough. But it does dovetail with a different body of law, the Permit Streamlining Act, and a requirement that the city review your application and determine whether it's complete within 30 days. And in that completeness determination, which is to say, did you file the building plans? Did you file your map? Did you file, all the other things we need for an application? If there's something missing, then the city will give you a list of items that are missing, but it cannot add to that. They can no longer keep tacking on new requirements. It's a diminishing list. So eventually, the developer will get to the end of the list and the city has to treat that application as complete. SB 330 also defines an objective design standard, which was an important thing. Referring back to the Housing Accountability Act, a project is protected if it meets the objective applicable standards, including design review standards. Well, SB 330 defined what that means. Said an objective design standard means a design standard that involves no personal or subjective judgment by a public official and is uniformly verifiable by reference to an external and uniform benchmark or criterion available and knowable by both the development applicant or proponent and the public official before submittal of an application. So if you have a requirement that is so vague, no one knows exactly what it means, such as your project needs to be consistent with the neighborhood character. That's not an objective design standard. And therefore the project does not have to meet that standard. It still would qualify for mandatory approval, even if it doesn't meet some of those standards. So there's been a movement now for cities to try to codify in more particular detail what their standards are. And that's, in some ways good and in some ways bad. It at least gives predictability so that a project applicant knows going in that the project they're applying for meets the requirements. On the other hand, some of those requirements can be quite onerous. And at that point, the state's Housing and Community Development Department might have to step in and say, this is a barrier to approval of housing and you're violating other state laws. again, just as a kind of parting shot, it's super important if any of these techniques are going to be helpful to getting housing improved, someone has to raise it at the hearing. Ideally, the person who ends up filing a lawsuit, if that's necessary, but at least someone needs to say, hey, City Council, you need to be aware that the Housing Accountability Act requires that you approve this project because it's consistent with the code requirements. You're at your fifth hearing, you can't do any more hearings, you need to make a decision. You know, a lot of things like that need to be raised, or it's almost as if those protections don't exist. So that's that for SB 330. I think we've got a couple questions. Rafa, I'll defer to you as a moderator if you want to take any of those now or add anything in.
There were a couple that I thought were relevant. Maybe you could expand a little bit on the Permit Streamlining Act and maybe the timelines that cities have to, review an application and then, approve a project or approve, the design permit or like the building permit.
Yeah. So let's see. I was just reading through a few of these also as you were talking, so I think I got it all. So Permit Streamlining Act sets out a timeline that in some ways is dependent on CEQA, which is a very problematic thing, the California Environmental Quality Act. The argument is cities have to approve a project, have to make a decision on a project, not even just approve. They have to make a decision within some number of days of the environmental review being complete. And I would have to go back and check. I think it may depend on what type of review is at issue. But the problem here is, I think this may be what you're hinting at, there's a difference between staff level environmental review being completed versus city level environmental review. And in trying to figure out what the Permit Streamlining Act deadlines mean and if they actually have teeth, if you're basing your deadline to make a decision on the project on the completion of environmental review at the city level, that could include an appeal. And that means there's no deadline to make a decision on the project until after the appeal is finished. And that's completely circular because you wouldn't even get to an appeal until the actual decision has been made on the project itself. So that's something we're in semi-constant battle with cities over. Not sure if that answers the question, but hopefully so.
I think, aren't there like 1 year or 2 year limits for certain, along the way? Maybe assuming that there was no, maybe ministerial, how much time? I guess we'll get to that. So let's hold that question.
CEQA includes those deadlines also, but they just don't have any consequence if you break them.
There was another one. How should applicants deal with requirements for conditional use permits? If an application complies with the objective standards, can it still be rejected because the city council feels like it?
It's a great question. It's one we're litigating in San Francisco right now. My argument has been, I should say our argument has been, the Housing Accountability Act only requires a project to comply with the objective applicable standards, the applicable objective standards, and then it must be approved. So if a standard, there are really two issues here. If a standard is not objective, so for example, lots of conditional use requirements include criteria like, is it consistent with neighborhood character? Is it on balance net positive for the city? That's not an objective requirement. And therefore, your project should not have to meet that. It can basically be disregarded. The other question here is the word applicable. So it must comply with applicable objective standards. And If the conditional use authorization can be approved without meeting every single requirement, sometimes it's just, here are some factors to consider. Here are 5 factors within the conditional use application to consider. You don't necessarily have to meet any of them. So the argument is they're not truly applicable if they don't have to be met or approved. So to really answer the question, it depends on the particular CU requirements for the city. But there's often a good argument that you don't have to comply with a lot of that. And now I should, given the time, I think I should probably hand the microphone over to Emily, who'll be tackling the next 2 topics.
All right, thanks, Ryan. Hey, everyone. I will be discussing accessory dwelling unit law first. So ADU law for short. ADUs, sometimes referred to as in-laws or granny flats, are essentially secondary homes that share a lot with a primary home. They contain kitchens or kitchenettes, have independent entrances, and can be studios, 1 bedroom, 2 bedrooms, or even more. The benefits of ADUs can be a relatively cost beneficial way to add another unit to a property and can be a source of affordable housing. No additional land or parcel is needed to build an ADU off the primary structure. So for example, if you wanted to add an ADU off to your home, you wouldn't need to buy a separate parcel of land. You could add it right onto, inside, or next to the existing structure. And costs are also saved because the state regulations in place mandate relaxed local permitting requirements. They mandate decreased fees and streamline the process for approval. So ADUs are an excellent way to provide housing for multi-generational living. And while an ADU generally cannot be sold separately, with some exceptions from the primary dwelling, it can be rented, which provides a homeowner extra income and the renter generally affordable housing. So a win-win. The types of ADUs under state law are a detached ADU, which, as the name suggests, is not attached to the structure. So this would be, for example, built in a backyard. An attached ADU, sometimes referred to as a bump out ADU. This is basically an addition onto the primary structure. A conversion ADU, which is this type of ADU converts existing space in the home or the primary structure. Could be a basement, garage, or other room in the home that one wishes to convert into a separate dwelling. And then lastly, we have a junior ADU. So this is similar to a conversion ADU in that it converts existing space in a primary structure. But junior ADU are smaller ADUs. They're restricted in size. They may have a kitchenette instead of a full kitchen. And sometimes local government can require that the JADU have interior access to the primary structure. And in that case, may share a bathroom within the primary structure. It does not need its own bathroom. So under state law, most permit applications for ADUs must be ministerially approved. As Ryan talked about earlier, essentially means over the counter without a public hearing. And there are also time limits in place for this ministerial review. So if you submit an application for an ADU in some circumstances, specifically with an attached or a conversion ADU, the agency, on an existing primary structure, I should say, the agency review of that application expires in 60 days. And if they don't make a decision on that application within 60 days, it's actually deemed approved under state law, meaning that in theory, the city should hand you your permit and you can put a shovel in the ground. Whoops. So, like the other state laws we just talked about, it also limits local agencies' discretion to deny an ADU application. Objective local standards only. The local agency may only review the ADU permit application for compliance with local objective standards, similar to the standard that Ryan discussed in the context of the HAA and the HCA. Another way state law limits agencies' discretions over ADU applications is by prohibiting local ordinance from establishing a maximum size of particular ADUs depending on the type. So, for example, local agencies cannot enact a rule that says the maximum of a one-bedroom ADU can be 600 square feet. Under state law, it has to be the maximum has to be at least 800 square feet. And for over one bedrooms, 1,000 square feet. And finally, state law prohibits agencies from requiring minimum lot sizes for ADU development. It can require setbacks in certain circumstances, but it cannot deny an ADU application on the basis of the lot size alone. And I see there are some questions. And Rafa, do you have anything to add on that?
I don't think so. Most of my interaction with ADU law comes in when cities are trying to make changes to other laws that inadvertently or maybe on purpose undermine ADU law, like restricting ADUs on new lot split laws because of SB 9, which we'll get to in a minute. Mm-hmm. I think ADUs have been really successful in recent years, and a lot of that's because of the state making these sort of sweeping standard sorts of zoning guidelines that help homeowners have a more predictable permitting process and allows this industry to scale a little bit better.
So I'll look at a couple questions here. Is the ADU time limit for actual issuance of a permit or for just the approval? So it is just for the decision. So essentially, there's 60 days to review the application. The city can deny it on a permissible basis. And then the time review would most likely start over, depending on the circumstances. But if they don't review it in that time, then it is deemed approved under state law, and a permit, in theory, should issue right away.
There was another question earlier. What's the difference between an attached ADU and a duplex?
That's a good question. An attached ADU is because they're considered ministerially under state law, they're restricted. There can be specific height and square footage restrictions on them that a building an additional unit would not have. So you're restricted in that manner. If you want something quick and simpler, an ADU is the way to go. If you want to have more flexibility to build another unit, then there are going to be more restrictions associated with that. But there's going to be the local agency will have more discretion over that, but there'll be less specifically mandated restrictions on it.
I think maybe one important one also is that ADUs typically aren't allowed to be sold separately from the primary residence.
Yeah.
Whereas a duplex, theoretically, most of them are apartments, but you could have essentially a 2-unit condo building.
Right. Yeah, great point. So how does it work if an objective standard requires a subjective finding? Ryan, you want to weigh in on that?
Sure. I think that's probably more of a Housing Accountability Act question. And if if it requires a subjective finding, it's probably not an objective requirement. So yeah, this gets back to that definition of what is an objective design standard. And it's one that everyone can know upfront by reference to some written standard. And it's not a mystery that requires some sort of subjective divining of meaning there. There's a recent Court of Appeal case, California Renters Legal Advocacy and Education Fund v. San Mateo, that dives fairly deep into this question of objectivity and delineates a difference between certain types of standards that are just very clear, like 40 feet means 40 feet. Everyone knows what a foot is, you can measure this. And then there are other standards that say the building must be painted green. Well, there are some limits to what the word green means. And you can still, that may require some amount of decision-making about whether something is green, but there are at least standards in place. There may be a definition of green, it's between this point in the color spectrum and this point in the color spectrum. So that gets into some interesting nuances. But to really answer the question, if you require subjectivity, then it's probably a subjective requirement, not an objective requirement.
All right, so moving on to the last tool we'll be discussing today, SB 9, Senate Bill 9. So this law created ministerial consideration review of lot splits and doubling units in urban single-family zoned neighborhoods. So SB 9 permits development of up to 2 units per lot in these neighborhoods, and it also permits lot splits, meaning you can split one single-family home lot into 2 lots. So what this means when taken, this is two separate statutes that they enacted. So when taken together, this means essentially that an owner may develop up to 4 homes on a parcel that was previously restricted to 1. So similar to the other state law housing tools we've discussed, SB 9 requires most applications for lot splits or development of the 2 units on 1 lot to be considered ministerially over the counter without a hearing. And it also prohibits local government from denying an SB 9 project on subjective bases if it meets the other criteria. If the project meets objective local standards, it must be approved. And SB 9 takes this objective standards criteria a step further as well. The law says that a local agency may not even impose objective standards on this type of project if the standards would physically preclude development of the homes altogether or preclude any of the proposed units from being at least 800 square feet in size. So that's a really strong tool to get housing built. Just switch the slide here. In addition, though, to limiting local agency discretion on projects under SB 9, the law also imposes limitations on the project applicant. So, for example, there is an owner residency requirement. Owners who seek a lot split must agree to reside in a home on one of the lots for a minimum of 3 years. The rental of any unit on the lot split must be may not be rented for less than 30 days, so no Airbnbs. There's also size restrictions on these lot splits. When a parcel is split, the new parcel can't be less than 40% of the size of the original parcel. So for example, if you had an existing home on 70% of the total lot space, a proposed lot split that would create a new parcel with the remaining 30% of the lot space would be denied because that's under the 40% rule. Another restriction is that after the split, The parcels must be no smaller than 1,200 square feet each. And the exception here is that if the city allows a smaller parcel, then that's okay. But under state law, it's must be no smaller than 1,200 square feet. And then certain properties, even if they meet the neighborhood zoning and size requirements, cannot benefit from these laws. So, for example, the proposed development of a new unit or lot split cannot demolish or alter rent-controlled or affordable housing, or any housing which has been occupied by a tenant in the last 3 years. Also, a property that has had an Ellis Act eviction in the prior 15 years cannot obtain the benefit of an SB 9. And there are various other restrictions too. The properties may not be located in certain potentially hazardous zones, fire hazard or flood zones, and of course, they cannot be located in historic districts, which has proved to be a very problematic restriction because a lot of the Bay Area is, as we know, is in historic districts. And finally, even if the property meets the application, or excuse me, meets all the other criteria, the local agency can still deny the project if there is specific adverse health and or safety issues that would result from development. So that is SB 9 in a nutshell. Rafa, do you have anything to add?
I could talk about SB 9 all day. Yeah, I'd say, there is an ongoing debate about how much discretion cities have to define what their objective standards are. And many different cities are taking different approaches. The law is pretty clear that the objective standards have to physically allow 2 800 square foot units. And many cities are interpreting that to say that, okay, well, that means that we can restrict our code to only allowing maximum 800 square foot units. And which is, in some cases smaller than what they allow under ADU law. So, while we're hoping that this bill will make a significant difference in allowing more, smaller homes in single family neighborhoods, and more options, especially the lot split option. That's a really helpful tool to allow folks to get traditional mortgage financing for their project, rather than having to do like a home equity loan or paying for a cash, paying cash for their project. And cities are coming up with creative ways to figure out how to not allow lot splits in certain situations. So this is really, because this law just passed last year, and was, I think, pretty well covered in the media, and there were a lot of folks who were up in arms about it. Many of that opposition, a lot of that opposition has continued in city hall chambers in attempting to restrict it as much as possible.
Okay, thanks. So I think we're going to open it up to questions, general questions now too. I do see an SB 9 question here. How do yard setbacks factor into SB 9 lot splits? So they can factor in. A local agency can require objective standards being met. However, as I said before, if it precludes development of a home altogether or precludes the units from being at least 800 square feet in size, the law says that the local agency can't apply it. So if in theory, that would mean if the setbacks precluded either of those things, then the local agency couldn't require them.
If other folks have other questions, you could raise your hands and we can call on you if you want to, be on the recording, or you can put more questions in chat. There were some other ones that came up such as basically what's a development, or maybe another way of phrasing that's where's the line between a new development and a remodel.
It's probably an HAA question, Ryan. And a good one, I might add.
Well, yes, it is a good question, and it's an unanswered question, I'd say, under state law. So Housing Accountability Act applies in most cases. We're talking about projects that include residential units only. Can also be mixed use. There are a couple different things, but usually it's residential units only. So does that mean you are remodeling residential units? Does that mean you're adding residential units? Does that mean you're adding a unit onto a residential unit? It's a debate. There's not an answer from the courts yet about what that means, or from the legislature. Though it would be nice if they did answer those types of questions for us. So I think if you were to surpass some threshold for demolition of an existing building, and that might be under local standard, but ideally you would have some state standard to reference there. So you're planning to demolish what exists and create something new that should constitute a housing development project under the HAA. But unfortunately, we just don't know for sure because the courts haven't told us yet.
And some cities are helpful in that they have a codified local ordinance that says, you know, if you are demolishing more than say 50% of an existing home, then that is a new development. Other cities don't say that. Some cities consider, you know, demolishing 95% of an existing home a remodel.
Right. And one might ask why state law should care about local municipalities' definitions of these things. And the answer is we don't know, but there aren't any other definitions to look at.
Does anyone else have any questions or comments? There was some good
Rafa?
Yeah.
Yeah, this is Charlie Eady. I've raised my hand, but I don't know if you can see that or not. I have a couple of questions. Yeah. An earlier question that I asked that never in the chat never got responded to is whether objective standards relate to zoning standards or public works standards as well. And some of those things, you know, don't come into play at the, you know, at the early phase of a project approval for use, but they might come into play later. But I think things like street standards, for example, you know, some jurisdictions have really extreme street standards that are, you almost always have to apply for some sort of exception or variation to that. And does that take it out of the Housing Accountability Act?
I'll tackle that one. The language in the HAA is applicable objective general plan, zoning, and subdivision standards and criteria, including design review standards. So some cities place those types of requirements within their subdivision code. Others do not. So that may answer the question for you locally.
Okay. Yeah, so it depends basically on where they put the standard is what you're saying.
I think probably so, but not necessarily the end of the story. Some cities like to try to avoid the law by taking, for example, a tax question and sticking it into the planning code, or taking a planning question and putting it into the public works code. And they try to get around things that way. So, you know, first question would be where in the code does it appear? And the second is, what type of a code requirement is it? Is it in the right place?
Okay, and then another question having to do with ADUs being ministerial. SB 9 requires projects to be approved even if they don't meet all the objective standards if it precludes a development. Does that apply to ADUs as well, or is that a whole separate deal?
So if I understand your question, you're asking if, are you asking about ADUs in the context of SB 9 or?
Yeah, so what I'm saying is that I've run into a situation where an ADU, which is ministerial, is being subjected to a standard that precludes the ability to do the ADU. There doesn't seem to be a protection as there is with SB 9 that says you have to find a way to approve the ADU. So I'm wondering, is this a, is the agency acting correctly here by saying that we don't have to approve the ADU because you don't meet an objective setback standard?
So the SB 9 law does take the objective standards criteria a step further by saying even if the project doesn't meet the objective standards, if it precludes development in these particular ways, then the local agency has to allow it. ADU law, I do not believe has that same teeth. The local agency can preclude development if it doesn't meet particular objective criteria.
Yeah, that's very interesting because in this situation, they can't get their ADU approved, but if they did a lot split, they'd have to approve it. Essentially the same thing.
Yeah, I would just add one comment, which is, as Emily mentioned earlier, if you're doing a state ADU, there are a lot of local standards that you don't have to comply with. Now, the planning code is just wiped away. So you at least have that tool.
What did you call that? An estate ADU or?
I'd state, like California state ADU, an ADU under state law.
Okay, well, that's what we're talking about here. So I guess I'm not clear. What could you explain?
So
that?
there are, if you pardon my talking about your topic, Emily.
No.
Some cities have local ADU programs with their own requirements, and then there are
I see what you're
law
saying.
ADUs.
If the city doesn't have its own requirements for an ADU, then the state standard applies. But if the city has their own standards, you have to go by theirs.
Nope. The city has their local standards, but the state standards still would apply. So
you can choose different programs to apply under. And if you choose the California program, then you do not have to comply with local planning code requirements.
You still have to comply with other objective standards. But for example, a city may have its own local program that allows more than the state law program does, but there's more the local agency has more discretion. Either way, they can impose objective requirements.
And they can preclude the ADU from being built.
Yes.
With those. Okay.
Right. The big one that I see is fire requirements, egress requirements. Those can be hard to meet. And even if you're proposing your project as an ADU, if you don't meet those requirements, then you may not be able to build.
Right. Yeah, but that's a safety thing, health and safety, which is in SB 9 as well. But if something's like an environmental setback that isn't a health and safety issue, it's just a decision that an agency made that say they want a 50-foot setback instead of a 40-foot setback from a riparian corridor, for example. Is that a health and safety issue?
It could be a, you know, a sensitive environmental issue.
Yeah, it could be, but if the facts indicate that it isn't, it's,
I think maybe one of those situations where, you know, the city, if they wanted to deny a project on the basis of a environment or a health and safety impact, that they have to have something already, you know, codified and knowable beforehand that describes what that environmental or excuse me, what that health and safety impact requirement is that is being violated by approving the project.
Right, and I don't know if a riparian impact would really constitute a health or safety impact. It may still be an objective standard that must be met. And we're litigating this up in Marin right now. Are you far enough away from a riparian zone? You know, some required setback there. Well, is it actually on the map to be considered a riparian zone? That's an objective question. And if you think that the city or the county has made the wrong decision, then you can challenge that. And in that case, the threshold question is whether the HAA applies. Because if the HAA applies, there are a lot of those kind of discretionary, call it as you see it type questions are just no longer important. They don't have discretion to say no anymore.
And the same with ADU law as well.
thank you.
Thank you.
All right. Any last questions? It is 7 o'clock, so I want to respect people's time.
Rachel has had her hand up for a while.
Oh,
Yeah,
okay. Thank you.
I can email this too if people need to go. One question I had was my city has for its R1 zoning a maximum of 5 units per acre. So to have 2 units on a property, you would need 0.4 acres, which is quite a bit, quite a large lot. So does SB 9 supersede that requirement?
So are you in an urban neighborhood?
I'm in a town of 13,000.
Okay. So
the lots are generally 6,000 square feet or, you know.
I mean, SB 9 would supersede any local, as a state law, yes, generally, it supersedes local requirements. So whether that complies with SB 9 would require further analysis, but SB 9 supersedes local requirements, to the contrary.
We're rewriting the land use element right now, and so I'd like to comment on that to them, that we should write it so that what it says in terms of density reflects what is allowed by the state law.
Absolutely.
And then the other question I had is I have basically a row home that's part of a planned unit development. It's 16 feet wide and 3 stories tall, and it's attached to another unit on each side. Can my HOA prevent me from converting my garage to an ADU?
The answer is probably not. ADU law has specific language in that precludes common interest developments from prohibiting ADUs in certain circumstances in the CCRs, and or restricting them, unreasonably restricting them. So you have an argument that they can't.
I also serve on our HOA board, and I would like to recommend, as we're rewriting our CCNRs, that we not write anything that's going to get challenged by the state.
That's a good idea.
Thank you very much.
I don't think the state would be challenging your CCNRs, but maybe, other homeowners who want to build.
That could use the state law to sue the HOA, because that's not in anybody's interest. So.
And it would really come down to the HOA, denying an ADU application flippantly without having like a reasonable reason for doing so.
Mm-hmm. Okay, I'm sorry, I have to go join another meeting. Thank you very much, everybody, for your time.
Thank you.
Is there time for one more question?
Sure.
So in the context of conversion ADUs, I understand you can do, for a multifamily situation, multifamily property, you can do 2 new units and you can do 25% of the existing units. You can convert non-habitable space and add 25% of the number of the existing units. And that's pretty clear in the law. Now, in the case of a legal non-conforming multifamily complex, let's say it's 10 units, but they're legal non-conforming as to density. I believe my interpretation of the law is that you can still do 25% of those units in otherwise non-habitable space and convert that non-habitable space to 25%, which would be 2.5 rounded to 3 units. Is that your understanding?
So you're including the non-conforming unit as non-habitable space?
No, let's say there's garages that are non-habitable space, and you've got, let's say the conforming density would be 3 units, but they've got 10 legal non-conforming built prior to the time that permits were required. There's a section in the conversion ordinance which says that you don't have to comply. You can convert a garage or other non-habitable space even if it doesn't comply with the zoning rules. But the question is specifically, if it doesn't comply with density, it's non-conforming as to density, can you then convert non-habitable space, such as a garage, to equal 25% of the number of the legal non-conforming units?
That's a great question, something that I would have to take a closer look at. I wouldn't be able to answer it immediately. Ryan, do you have any thoughts about that?
I would want to look at it more closely.
Yeah.
Yeah, anyway, yep, well.
It's an interesting question, though.
Yeah, I have a specific situation where that's come up, and love to talk to you. I guess, yeah, anyway, okay, talk or not.
Emily, do you want to put your contact info in the chat? Emily
Sure.
heads our SoCal office, so if you're in that area, you might want to.
Oh, great.
Reach out.
Yes, I am in SoCal. I'm in Santa Cruz. So, yeah, great.
All right.
I think
I'm going to stop the recording. And I think with that,